Check 1 2. Check 1 2.
Yeah, I think Emily said she had everything locked already.
Check 1 2.
Yeah, I think Emily said she had everything locked already.
Good morning. This is April 3rd, 2024. We have come for an evidentiary hearing in file number ET 2024-0183 in the matter of Evergy Metro, Inc., doing business as Evergy Missouri Metro, and Evergy Missouri West, Inc., doing business as Evergy Missouri West's solar subscription rider tariff. My name is Nancy Dippell, and I'm the regulatory law judge presiding over this hearing today. We are both broadcasting this on our internet channel, but also we have a WebEx for one of the commissioners and maybe others, depending on how the hearing goes. And also our court reporter is remote this morning. So my first request is that anyone online, be sure you're muted unless you need to speak. That will keep the interference down and make it so that the court reporter can hear. Anyone in the room, please speak into the microphone when you are speaking again so that the court reporter can hear and record everything. And I would also ask if you have any electronic devices with you in the hearing room this morning that you mute those. So we will begin with entries of appearance. Can I start with the company?
Good morning, Judge. This is Jim Fisher. Let the record reflect the appearance of Roger W. Steiner and James M. Fisher on behalf of the two applicants in this case, Evergy Missouri Metro and Evergy Missouri West. Our contact information for the court reporter is on our position statement in the case. And unless you need it stated on the record, I'll just leave it at that.
That's all right. We'll make sure the court reporter has your correct contact information. And for staff?
Good morning, Commissioners, and Your Honor. I'm Colonel Graham.
Mr. Graham, speak into the microphone, please.
Start again. Good morning. I'm Paul Graham. I represent the staff of the Missouri Public Service Commission, and our contact information is on our pleadings and on file in this case.
Thank you. And I had contact from the Office of the Public Counsel and from Renew Missouri Advocates before the hearing. They both asked to be excused from participating in the hearing. And with my usual caveat that if you're not present, then you waive any objections or opportunity to present evidence, those parties are excused. So the exhibits have been pre-marked. The pre-filed exhibits have been pre-marked, and we will follow generally those exhibit numbers, as well as the parties presented their order of cross and order of witnesses. Obviously, since it's unusual that we just have two parties out there, and if the company is welcome to stay where you are, but if you decide you want to move up front, you can do that also.
Force of habit will just.
It's like being in church. We prefer the back.
Okay, so we will have the commissioners with us at various times. Commissioner Holzman is currently on WebEx and is remote. And Commissioner Holzman, I didn't know if you wanted to say a couple of words before we got started.
Thank you, Judge. Just wanted to thank everybody for their participation today. And I'll chime in if I have any questions, but at this juncture, I'll just be listening until we go to agenda.
Okay, thank you, Commissioner. And I have, as I said, Chair Hahn and Commissioner Kolkmeyer here on the bench with me. If everyone would please try to identify yourselves before you speak, that will also help the court reporter to get a clear record today.
Judge, the Commissioner Roop is online as well.
Oh, okay, Commissioner, sorry, I didn't see you there. All right. Wanted to make sure I hadn't missed Commissioner Coleman as well. Okay, but then we can go ahead and, well, I will say that the commissioners have agenda at 10:15. So my plan is to stop at 10 and take a break. Probably the agenda is fairly short, so we would take a break maybe till like 10:35. I think that would give time for everyone to get the business done and make it back down to the hearing room. So let's go ahead and begin with opening statements then. Evergy?
Thank you, Judge. May it please the commission. For the court reporter, my name is Jim Fisher, and Roger Steiner and I will be representing the applicants today, Evergy, Missouri Metro and Evergy, Missouri West.
Thank you.
This proceeding is a continuation. I'll wait just a minute, Commissioner. Welcome. This proceeding is a continuation of filings related to the Solar Subscription Rider Program tariffs and the company's efforts to reflect the true-up of the final Hawthorne construction costs into the tariff charges. I'm going to refer to this for the court reporter. It's the Solar Subscription Rider Program. I'll be referring to it with an acronym SSP today. The case is intended, as I've got on the screen, to revise the SSP tariffs to slightly increase the solar block subscription charge pricing. Secondly, possibly expand the availability and address monthly billing under residential time of use rates. Also, to revise the tariff to better incorporate future solar projects and to revise the non-residential participation limits. In total, these revisions seek to execute on the pricing update contemplated in the original tariff and to enable the SSP to better meet the needs of customers seeking direct access to renewable energy. The SSP program is a key component of the company's efforts to increase the direct availability of renewable energy to its customers. Since approval in 2018, the company has been diligently establishing customer interest and enrolling customers as is required by the tariff to construct the solar resource. Once the subscription levels and other terms were met, the company executed a cost-effective build of a solar resource facility to serve subscribers. The company constructed the solar array on company-owned land out at the Hawthorne generating unit, which took advantage of the nearby electric infrastructure to connect. The solar array was built to not only serve the Missouri SSP program, which included 1.4 megawatts for Evergy, Missouri Metro, and 0.9 megawatts for Evergy, Missouri West, but it also included a build for 5 megawatts to meet other company solar resource needs so that all Missouri customers could benefit from the larger solar resource facility and at a lower cost. Now that the Hawthorne solar plant is complete, the charge modifications proposed in this case will allow the company to reflect the final resource cost in the solar subscription charge, a step which was contemplated in the original SSP tariff. Now, second, regarding revisions to the tariff availability section, The billing provisions of the existing tariff were designed under the traditional block rate designs and do not accommodate billing under the company's residential time of use rates beyond that residential peak adjustment charge, which is the low differential, the default rate. The company has filed tariff revisions that will implement a method to possibly expand the availability of the SSP to the more highly differentiated time of use rates if that's the Commission's desire. However, due to principally the billing complications that I'll talk about today, the company agrees with staff that the Commission may properly determine that it is appropriate that customers not be able to participate in the SP program while taking service on the more highly differentiated time of use rate schedules. The company understands that the SSP participants are primarily interested in access to renewable energy, not access to a specific retail rate. Participants are currently limited under our tariff to the low differential time of use rate option, and the company has not observed cancellation of subscriptions or received customer inquiries concerning the unavailability of other TOU rate options. Now, limiting rate availability to the current default TOU rate would eliminate the need for further bill system configuration, and by that I mean changes to our billing system, and would eliminate the need at this time for the Commission to establish a method for allocating the solar resource output between the TOU periods. And that's one of the more difficult issues, I think, in the case that if we go down that path. Now, alternatively, it would make sense from Evergy's perspective for the Commission to wait to implement the billing provision changes until the next solar resource is built. Waiting until the next solar resource is built will give the company more time to make the billing system changes and would be a smoother transition to expanded availability of the SSP to the higher differential TOU rate options. And I'd encourage you to talk with Brad Lutz, who's our second witness today, about that option if you're interested. Finally, the proposed revisions will streamline future expansion of the SSP program as customer interest grows and would allow the company to address other renewable opportunities as they come along in the future. Now I'd like to talk first about the areas of agreement in the case. Let me reiterate that the company agrees with staff that the Commission may properly determine that it's appropriate that customers not be able to participate in the SSP program while taking service on the more highly differentiated TOU rate schedules. Now, if the Commission agrees with that policy perspective and leaves the existing restrictions in place, then many of the other issues in the case become moot. The only issues that would be left are, first, should there be a slight increase in the rates, about 0.3 of a penny per kilowatt hour, to reflect the updated actual cost of the solar facility in the case? And then second, should the company's tariff provisions for future expansion of the SSP program be approved? Those would be the only two issues left if we decide to leave the current restriction in place regarding time of use rates. Now, however, if the Commission decides to expand the SSP program to allow the participation of subscribers that are on the more highly differentiated TOU rates, then it will be necessary to address a billing provision that I'm going to discuss in just a minute. Now, the second thing that we agree about is the company and the staff agree that the solar subscription program should not be expanded to include the separately metered electric vehicle rate option that we have under the time of use rates. Customers would still be able to participate in the SSP under the customer's primary meter, but we agree that these customers should not be given a second opportunity to subscribe under the separately metered electric vehicle rate tariff. Now, going to the third thing, Evergy agrees with staff that the securitized utility tariff charge should be applicable to all metered kilowatt hours without any reductions for the participants' share in the solar resource energy production. And fourth, we agree that customers should be credited for the net excess energy at the current rate in the company's parallel generation tariff. That's similar to how net metering is treated today. But let's look at some issues that are still left. The first issue to be decided would be, should Evergy be allowed to reflect the actual cost of the solar facility in the charges that are part of the SSP? The solar block subscription charge is made up of two costs. The first is the solar block cost, and the second is the services and access charge. Evergy is proposing to change the solar block cost and is not recommending any changes to the services and access charge. Evergy requests an increase in the solar block cost from 8.84 cents to 9.13 cents per kilowatt hour to reflect the final actual construction costs out at the Hawthorne Solar Facility. The purpose and timing of this pricing change has been anticipated since the company proposed the pilot program and received commission approval of the solar subscription pilot tariff back in case number ER-2018-145 and 0146. All of the parties have been aware of the pricing change process because it's right there laid out in the tariff, and the company has been working to complete that process. The additional revenue produced from this change is approximately $93,000. Yeah, it's my understanding that staff believes the company needs to wait until a general rate case to make this change. Evergy respectfully disagrees. This pricing change is contemplated by the commission-approved SSP tariff and is legal authority to make this change at this time. Now, the second area of disagreement is a more technical issue, and it involves how peak and off-peak energy is handled for purposes of the program. Should the company's allocation method or staff's customer-specific method be used for calculating the impact of peak and off-peak usage and billed accordingly? This would be an issue only if the commission decides to expand the SSP to allow subscribers to participate that are on the higher differential TOU rates. As Mr. Lutz explains in his testimony, Evergy believes that the current allocation method is the most practical method. Staff is proposing a two-step method, which would be customer-specific and require manual adjustments every month to the bills of each participant in the SSP plan. Now, Evergy's billing system won't automatically accommodate the staff's approach, and we don't believe it's the best way to reflect the differences between peak and off-peak consumption in the program. And I'd encourage you to ask again Brad Lutz about that technical issue too. So, then there are a couple more issues to be decided. The third one is, should non-residential customers be allowed to subscribe under the SSP up to 100% of their energy usage? Evergy believes that non-residential customers should be allowed to subscribe for 100% of their energy consumption. But as I understand the staff's position, staff would limit it to the current level of up to 50% of the non-residential customers' annual energy consumption. In working with non-residential participants, it's become clear that these customers often have sustainability goals or mandates for renewable energy that could be satisfied by higher levels of subscription under the SSP. The company proposes to increase the subscription level for non-residential customers from the current up to 50% to up to 100% of their annual energy consumption to assist non-residential customers in achieving their sustainability goals or other renewable mandates. Now, the fourth issue would be, should the terms for future expansion of the SSP be modified as proposed by the company? In 2018, when the SSP tariff was first designed, cost trends signaled that solar resource costs would be being reduced in the future. And under that expectation, the current tariff restricts program expansion only if the solar resource cost is less than or equal to the cost of the original solar resource. That provision made some sense at the time when we thought all these costs were going to be coming down because it would ensure ongoing cost reductions for participants. But unfortunately, the market for solar resources developed a little differently than expected. Supply chain limitations, material costs, and inflation have contributed to keep solar resource prices higher than expected. The company has also continued to receive customer interest in the SSP program, and some customers are frankly interested in participating even if the subscription prices are a little higher. The company is seeking to modify the terms associated with program expansion for the future to allow the option to expand even if the costs are going up somewhat. If the solar resource is higher than the current costs, the company would still build the solar resource facility after it received a certificate or a CCN from the commission. Now, finally, the last issue that would be decided is it's a fairly minor one, I think, but it would be should the 3-month waiting period for non-residential customers be eliminated as proposed by the company. The original 3-month waiting period was added to ensure that residential customers are given sufficient time to subscribe to the initial resource established in the program. The terms were actually quite successful, resulting in 99% of the participants being residential customers. But going forward, the wait list now serves as a means to ensure that participation by residential customers. Participants are served on a first-come, first-served basis. We don't believe the 3-month waiting period is necessary today, and it should be eliminated. In the hearing today, we'll be presenting 2 witnesses. Kevin Brannon will explain how the actual cost of the solar facility will be reflected in the solar subscription rates, and Brad Lutz will discuss the remaining issues, particularly the tariff provisions. And unless you have questions for me, I will sit down.
Let me see if there are any commissioner questions for Mr. Fisher, Chair. None? Commissioner Holzman or Commissioner Roop, just speak up if you have. Oh, Chair Hahn
Thank you.
does have a question. Hold on.
Morning.
Good morning. Thank you, Mr. Fisher. Sorry, it took me a minute to review my notes to see if I had any
Not a
questions.
problem.
On the very first issue of, should Hawthorne be included in the solar block charge of the SSP, you talk about how the price per kilowatt hour would change from roughly 8 cents to a little over 9 cents per kilowatt hour, resulting in roughly $93,000 total revenue. Is that over? And my understanding is that over the life of the facility?
That's $93,000 per year over the life of the facility, yes.
$93,000 annually.
Annually, right.
Okay.
It's about a 0.3 of 1 penny is how much the increase is.
And what is the life of the facility estimated at?
I think I'll have to defer to Brad. I think it's 40 years, but I'm not sure.
Thank you.
Are there any other commissioner questions?
Thank you very much.
Mr. Fisher, before you step down, can we go ahead and mark your presentation slides as a demonstrative exhibit, just so that I can have those in the record?
I have copies of that, but I noticed I did have a mistake that I corrected on the one that was shown on the board. It's not it is a 3-month waiting period. I had a 30-day waiting period in the slides show, but I'll distribute that with that caveat, okay?
Well, could I get the corrected version?
Oh, certainly. Yeah, I could do that too.
To actually mark and put in with the other exhibits. I'll mark that as exhibit number 5.
And I can present that later by electronically filing, or,
Or you can just bring me a copy, whichever.
all right, sounds good, thank you.
And staff, your opening.
If it please the commission. Good morning, commissioners. I'm Paul Graham. I'd like to start right out before I get to my script here by inviting the
Getting a
commissioners,
little closer. Yes,
by
thank
inviting
you.
the commissioners to remember Commissioner Hahn's, Chair Hahn's question. Staff emphatically disagrees with the answer that it has received or heard from the company. I'll get there in a minute. This case breaks into two parts. Staff's witness on the first part is Sarah Lange. Staff's witness for the second part is Cedric Kunigan. I'm going to endeavor here to describe staff's case with a minimum of legal accounting and PSC jargon. I'll probably break that hope right away, but that will be my endeavor. Ms. Lange, largely with many additions and explanations, covers the peak and off-peak usage issue that Mr. Fisher referred to. Ms. Lange's part of the case concerns the components of customers' bills related to their participation in the solar subscription program. For the RPKA, there I did it, Residential Peak Adjustment Rate Plan, on which 85% of residential customers are served, this case concerns how customers' bills get credited for their participation in the solar subscription program, taking into consideration the time of day when customers use power. Depending on the time of day a customer uses power, the components of the calculation will vary. There will be either a charge or a credit applied to a bill component depending upon the time of day the power is used. For example, the time period between 4 p.m. and 8 p.m. is important. In our PSC jargon, that time period might be called peak time of use. A customer's bill will contain a specific line item calculation for power used in that time period. Boiled down to its essence, for the RPKA rate plan, it is staff's position that with respect to the calculation of the bill for power used during peak time of use, neither the company's present practice nor its proposed tariff gives a credit to customers that fairly recognizes their participation in the solar subscription program. That's what Ms. Lange's part of the case concerns, simply and directly. Ms. Lange's testimony and presentation explains exactly where, how, and why not, and calls out many examples of this kind of unfair customer treatment throughout the proposed tariffs and the different time of use options offered to customers. Suffice here to say that the problem is endemic and appears across the board. Ms. Lange has written, and staff is presenting for approval, in this case, specimen tariffs which address the problem. Staff has also provided tariff language for potential billing for customers taking service on rate plans other than RPKA. With respect to these other rate plans, staff's proposal is simple. Staff asks that the Commission decide upon the balance that is appropriate between customers' options, arbitrage opportunities, and billing simplicity. Staff has proposed a way to address, or a way of addressing, the RTOU2, that's Residential Time of Use 2 period, and RTOU3, Residential High Differential Time of Use rate plans, interaction with the SSP rider. If the Commission determines that it is appropriate policy for residential customers who participate in the SSP to have access to these rate plans, and requests that if the Commission determines that it is appropriate for SSP participants to access each option rate plan, that the commission either order either that the tariffs that staff has submitted be adopted or used, or order the specific tariff language which the commissioner wants. The idea here is to get this case done with a minimum amount of argument going on for the next month or so about the language of the tariffs. That's why the staff is asking that the language itself be addressed one way or the other. Either that the tariffs that we have proposed, that staff has proposed, be adopted, or that the commission advise us as to the language that goes into these tariffs be written now. Either way, staff asks the commission to order that the tariffs be fully implemented as soon as possible. I'm going to turn to Cedric Cunigan and just write in your mind up here $93,000, which the chair asked about. And kind of keep that number up there as I address these issues in the opening statement. Mr. Cunigan's testimony focuses on the company's proposed changes to solar subscription pricing and subscription levels. This opening will focus upon the proposed changes to solar subscription pricing. Evergy's proposed tariff changes its solar subscription program pricing. Specifically, it proposes changing the solar block charge from 8.84 cents per kilowatt hour to 9.131 cents per kilowatt hour. Let's just say from 8 to 9 cents. But its proposed tariff makes another change. It removes the following promise made in the company's earlier tariffs. A promise that the solar block cost will not exceed 13.88 cents per kilowatt hour. So put two things up in your mind, $93,000 and the word estimate. And look at the tariffs. The word estimate appears repeatedly, and it appeared in the December 2018 tariff. It appeared in the January 2023 tariff. And with respect to block billing, it appears again in the proposed tariff. We ain't done, is what that word means. $93,000 is not the end of the road. Staff opposes the change for several reasons. The first is that it blatantly violates a promise which Evergy repeatedly made to its current, now subscribed, solar subscription program participants in order to induce them to enroll in this program. That promise is represented in the following publication, which Evergy posted on the internet and was currently up on the internet in May of 2023. That is to say, between January 9th, 2023, when the now effective tariff went into effect, and the time when the new tariff was proposed. And this is what it said. Q&A, frequently answered questions. Will my solar subscription charge be subjected to additional increases in the future? Answer, the solar block subscription charge for the cost of the resource will not increase and may go down if we install additional cheaper assets, period. No ifs, ands, buts, subject to this, subject to that, none of that, period. The second reason, tightly woven into the first, and I hesitate to go into this because it's a bunch of law, that staff opposes the change is that it violates the filed rate doctrine, its corollary prohibition against single issue rate making, and the public policies underlying those laws. Now, in this opening statement, staff will not work its ways through the levers, bells, and sirens and whistles of the filed rate doctrine or the prohibition against the single issue rate making. Here, staff will focus on public policy. What policy? The public policy that customers should be able to count on promises. Not rocket science. The major public policy concern here that is stated in case after case after case after case that talks about the filed rate doctrine is that, well, let me read it out. The major public policy concern that the legal rules seek to achieve is that customers know prior to purchase what rates are being charged and are therefore able to make economic or business plans or adjustments in response. The public policy that the filed rate doctrine serves is to, quote, provide advance notice to customers of prospective charges, allowing the customers to plan accordingly. Now, the question that was put up on the internet addressed exactly that, and the answer was clear and unambiguous and without ifs, ands, or buts, no increases in the solar block, period. May 2023. On the heels of that, here comes this new tariff. With respect to the proposed solar block rate tariff increases, in a sense, this case is a tale of three tariffs. One became effective in December of 2018. That tariff set out an estimated solar block tariff amount. The next one became effective in January of 2023. That tariff set out a different estimated solar block tariff amount. Between 2018 and 2023, Evergy built the Hawthorne plant. Evergy started billing customers for the Hawthorne service in April of 2023, but the first bill back-billed them through January of 2023 based on the January 2023 tariff. Then Evergy filed and withdrew another tariff. Then it filed still yet another one, the one now before this commission, changing the solar block charge. The first two tariffs contained the following. Now, here we're getting to the nub of this thing. The first two tariffs contained the following promise with respect to the solar block charge. The solar block cost will not exceed 13.88 cents per kilowatt hour. The third tariff now before us today, and I'm going to use this word, revoked the promise. The third tariff continues to call the solar block charge an estimate, thus clearly forecasting still further changes, but with the promised cap now gone, thus using the company's excuse for being here today that everything was clearly an estimate of an anticipated change. One can only conclude that the company is now planning on another change and plans on making future changes to the solar block cost with no need to honor the 13.88 per kilowatt cap promise. So where did the $93,000 just go? Out the window. That promise made to prior subscribers is now a dead letter for those prior subscribers. Now let me make something clear here lest there be any misunderstanding. Staff is not stating that the company is necessarily trying to get more money. It appears to us that it will, but that point is not the sine qua non. That is not the essence of staff's argument that the change should be rejected. Staff does not hang its hat on that argument. The point here is not about what the company gets in the end. The point is, what is the customer paying at his end? In that regard, 2 points are unassailable. First, the tariff increases customers' block rates. Second, the proposed tariff removes a cap on future block rate increases. It simply revokes an earlier promise made to customers who have already subscribed. If future solar block costs exceed the now removed cap, customers who have already subscribed before the cap was removed can expect to pay above that cap. So $93,000 is not what the case is about. The point, The point is that the whole public policy behind the filed rate doctrine is under attack. Subscribers were lured into signing for the program on an express representation that the solar block charge would not go above the stated cap. On that basis, they were encouraged and did in fact enroll in the program. The purpose of the filed rate doctrine is to make companies make good on these promises. The tariff now before the Commission unambiguously reneges on that promise as made to customers who have already subscribed, and not only violates the filed rate doctrine on its face, but represents a direct assault on its conclusion. Staff asks that the Commission that concludes my statement at this point. Questions?
Are there any commissioner questions for Mr. Graham? Chair? Are there any commissioner questions online? Not. Oh, Chair Hahn?
Thank you, Mr. Graham. One question I had is, once customers are enrolled in the SSP, can they unenroll, or is it a contractual agreement for a particular duration?
You know, I'm sorry, Commissioner, I don't know the answer to that question. I simply do not know. I don't know if, Cedric, can you address that in his testimony?
Perfect, thank you.
Thank you for getting him an advance notice.
Thank you.
Are there any other commissioner questions? I have just one question for you, Mr. Graham. Mr. Fisher laid out what he thought the staff and the company were in agreement on, and what issues would remain live and so forth, depending on how the commission ruled. Are you in agreement with the way he laid those issues out?
Again, I'm going to equivocate in my response. I didn't hear anything that troubled me. I was, however, receiving questions or concerns from one of my clients. I'm going to call him sitting at the bench here. So let me just fudge on that one too. I will say that the points that I have addressed here in my opening statement are the ones that I thought were compelling in this case. But some of that other stuff, I know that we have some disagreements on the wording of things, and I'm just going to leave it there,
Okay.
rather than make admissions up here.
All right, thank you. I believe that's all for you.
Thank you.
Thank you. Let's go ahead then and begin with our first witness, Evergy.
A company calls Kevin Brannon. Up there, Kevin.
Mr. Brannon, if you would raise your right hand.
Yes.
Do you solemnly swear or affirm the testimony you're about to give at this hearing will be the truth?
Yes, I do.
Thank you. And it's hard to get close to that mic,
Sure.
but if you could kind of lean into it, I'd appreciate it.
Absolutely.
Thank you.
Please state your name for the record.
Kevin Brannon.
Mr. Brannon, where do you work and what is your position?
Yes, I work for Evergy. I am the senior manager of our distributed energy resources products team.
Thank you. Mr. Brannon, did you cause to be prepared a direct testimony which has been pre-marked as Exhibit 1 in this case?
Yes, I did.
Do you have any changes or corrections to that testimony?
No, I do not.
Would your answers today be the same as the answers contained in Exhibit 1?
Yes, they are.
Are the answers in Exhibit 1 true and complete to the best of your knowledge, information, and belief?
Yes, they are.
Judge, I would offer the admission of Exhibit 1 into the record, and I would tender this witness for cross-examination.
Would there be any objection to Exhibit 1?
None from staff.
Thank you. I will admit Exhibit 1. And staff, you may go ahead with cross-examination. right. Are there any questions from the commission? Chair Hahn? I'm looking on the bench, and then if there's any questions from the commissioners online, I'm going to let you just speak up. Okay, Chair Hahn.
Good morning, Mr. Brennan. One question is, where will the ongoing O&M cost of the Hawthorne facility be captured? Is that in the solar block component of the tariff?
That's correct. The fixed component, the solar block charge.
Okay, thank you.
Okay, well, is there any recross based on the commissioner's question? Mr. Graham?
No.
Is there any redirect from Evergy?
One moment, Your Honor. No questions.
All right then, Mr. Brennan, you may step down.
Court reporter here. Who was doing the examining for Evergy?
I'm sorry, that was Roger Steiner.
Thank you.
Thank you for asking.
Sure.
All right, Evergy, if you want to call your next witness.
Thank you, Judge. We would call Bradley Lutz to the stand.
And that was Mr. Fisher speaking.
Yes, it's Jim Fisher.
Hello.
Hello, would you please raise your right hand? Do you solemnly swear or affirm that the testimony you're about to give at this hearing will be the truth?
I do.
Thank you. Mr. Fisher, you may go ahead.
Thank you, Judge. Please state your name and address for the record.
Good morning. My name is Brad Lutz. I work at Evergy at 1200 Main in Kansas City, Missouri.
Are you the same Brad Lutz that caused to be filed in this case direct testimony, which I'll tell you has been marked as Exhibit 2, rebuttal testimony, which has been marked as Exhibit 3, and surrebuttal testimony, which has been marked as Exhibit 4?
I did.
Do you have any changes or corrections that need to be made to any of those documents?
I do.
And would you put on the record what that change would be?
Yes, I'd like to offer a correction to my rebuttal testimony, specifically on page 11, starting on line 7, and the phrase beginning EV only plan through the remainder of that sentence should be struck. It was not our intention to include that specific element in this answer.
And let me get you just to repeat that,
Yes.
that line and page number again.
Yes, it would be in my rebuttal testimony, page 11, starting on line 7. It extends into line 8.
All right, thank you.
Do you have any other changes that need to be made?
I do not.
If I were to ask you the questions that are contained in those documents, and with that change in mind, would your answers be the same, and are they true and correct to the best of your knowledge and belief?
They are.
Judge, with that, I would move for the admission of Exhibits 2, 3, and 4, and tender Mr. Lutz for cross-examination.
Would there be any objection with that correction to Exhibit 3 to any of those Exhibits 2, 3, or 4? Mr. Graham?
No.
Thank you. With that, I will admit Exhibits 2, 3, and 4. Is there any cross-examination from staff?
I hesitate. Do you happen to have Mr. Lutz?
To speak again.
I turned it off inadvertently instead of on. Thank you. Mr. Mr. Lutz, do you have in front of you the currently effective tariffs?
I do.
Not to be unfair, but would you be able to point to the language and read it out that limits partition to RPKA at this time?
That language is not specific to the current tariff,
Okay.
but would be represented by the monthly billing provisions found on sheet 39B of the Evergy Metro version, for example.
Version of a tariff?
Yes, 39B is a sheet number of the tariff, and I'm referring to the Metro version. I do not have both.
All right,
In front
but
of
you
me.
have directed our attention to where we can look for this language with respect to Metro.
Correct, correct, and okay.
Are there any questions from the commissioners for Mr. Lutz? Chair Hahn?
I do have questions. Sometimes it takes me a minute to gather my
Sure.
thoughts.
Take your time.
Good morning, Mr. Lutz.
Good morning.
As contemplated by staff, these tariff changes would actually occur in a rate case rather than through this tariff change. In your view, how would that work if you have this facility and you have Evergy West and Evergy Metro cases? How would you go about allocating or changing the rates in one and then potentially the other? So how would you envision staff's proposal, as in the rate case, to change the tariff prices to work? And I'm going to ask staff the same.
Okay. Yeah, just thinking off the cuff, I mean, it would take a level of coordination to make sure that those prices were to stay aligned through the processes as they traverse the rate case. But beyond that, have not really given it a lot of thought of what the rate case process would look like. You know, fully expecting that the process that we had laid out in the original tariff from 2018 would have been the preferred path.
Earlier in the opening statement, Mr. Fisher said that this tariff change was contemplated previously, I think in a 2018 case.
Mm-hmm.
Tell me how it was contemplated in conversation, or what memorializes that contemplation.
Certainly. I would offer that the tariff itself is the best representation of that contemplation. In the way the program was set up, the company had to go out and achieve subscribers, build a list of 90% of the resource to be deployed to be fully subscribed before we could execute the build. So it created this process where we had to do a lot of preliminary work before we could build the resource. And without the build of the resource, we wouldn't know what the final price would be. So we set up this kind of order of things, if you will, in the 2018 case and in that tariff to memorialize those processes. So we would go out, we recruit, market, gain subscribers, build the resource, and then finalize the pricing in that tariff to lock it in and to go forward.
Okay, two questions about that.
Mm-hmm.
Is Hawthorne fully subscribed?
Yes, with a waiting list.
Okay. I had another one. Can't remember. Oh, yes, I do. What is the in-service date of the Hawthorne facility? It seems as though there's dispute about when the plant was placed in service. So from Evergy's view, when was the plant placed in service?
Right, and I would offer, I don't think there's as much dispute, but it's because of steps that we're taking to bill customers under it versus the in-service date that we've offered is more related to the accounting, the inclusion into rate base, those aspects that go along with the asset. But I believe that was in March or May Thank you, thank you. I'm sorry, I was looking to Kevin Brannon. He has helped in that matter. So May would be the in-service, and the system was operational in January.
Of this year.
Correct. Or, no, of 24,
23.
23, yes, the
Okay.
prior year.
Okay, I think that's all.
Okay.
Are there any other commissioner questions for Mr. Lutz? Are there any online? Not seeing any. I think I have just one for you myself, Mr. Lutz. Well, related to that in-service date, do you agree with Staff Witness Cunningham statements in his testimony that the company is retroactively billed customers back to April 1st of 2023?
Yes, the final price was applied to all customers subscribing back to that January operational date, the date when those customers started to receive energy from the system reflected on their bill.
And maybe just walk me through that again. So the January 2023 date represents what?
Right, in January is when the system became operational and started delivering energy to the grid. The company had a commission-improved tariff in place to allow us to charge those subscribers a rate in January. We started executing the program under the terms of that tariff in January. But it wasn't until the in-service date in May that we had the final pricing, the final amount for that resource. So the decision was made to backbill that so that those customers were paying the full price, the true price of that resource for all of that participation.
And the in-service date in May represents when everything was final, or
Right.
what does
Right.
it mean?
Right.
Tell me what in-service date means.
In my opinion, and oftentimes the in-service is more of an accounting and somewhat an engineering phrase. They'll use engineering parameters oftentimes as the criteria, but the purpose is when is this brought into the books and records and the rate base of the company. That's that in-service term. And so the system was connected to the grid, generating, doing the work that it normally does in January. But a process was put through it from an engineering perspective to prove certain criteria before it could be judged in service. This is something we do for many of our generation resources, is to have this in-service criteria established and met. And so that did not occur until May. That was completed in May. Now, a little bit more a flavor there. It usually involves some kind of site visit where the asset can be observed visually. There are engineering tests, performance measurements that are evaluated to make sure that the system is truly doing what it was intended to do.
Okay, thank you. Will Evergy have any unused capacity from this solar facility?
Within the constraint of the solar subscription or the resource in its entirety?
The resource in its entirety.
Yeah, that's going to be a little bit more complicated because the resource is split amongst a number of purposes. But as far as saying that there's any unused energy from it, I would say no. That the energy will always be fully utilized. It's just a question of how that's allocated or paid for through the various programs or uses of this resource. So the energy is going to be fully consumed by Evergy in some manner through one of these programs or through our just general use of the asset in serving all customers.
And is it possible to, I mean, what is that manner going to be? How are you going to divide between West and Metro?
Right.
When West is currently seeking a rate case?
Well, the utilization of the resource is independent of the rate case. And what we've done is superimposed a fixed allocation of all energy produced from that system. So regardless of what happens in the case, that energy is moving based on that fixed allocation every month. So it's all been fixed and it's just allocated out based on that those percentages regardless.
Okay. Are there any, let me ask if I stirred up any other questions from the commissioners. All right. Well, it is 10:03, so I'm going to ask you to hold your recross and redirect until we return from a break. So we'll go ahead and break until 10:35 unless things run long, and then we'll be a little late. So let's go off the record.
Thank you.
We can go ahead and go back on the record. We have returned from our break. Mr. Lutz is back on the stand, and we were up to further cross-examination based on commission and my questions. Is there anything from staff?
Yes, Your Honor, a few. Sir, would you agree that the price that was estimated in the original tariff that was set out in December of 2018, one of its purposes was to gather subscribers?
Yes.
Did the company ever intend actually to charge that amount?
No, I don't think there was any plan that that would be the final amount.
That's not what I asked. Did the company ever intend to charge at any point in time the amount that was set out in the original tariff of December of 2018? Was the company's intention at any point in time to charge that amount?
Counsel, could I clarify what price you're talking about there?
I don't have it in my mind, but whatever the charge was that was set out in the December 2018 tariff.
Yes, may I go ahead?
Yes.
I would say only in the occasion that the final price proved to that number, that would be the only occasion where we would have charged that price. Otherwise, it would be subject to whatever the final cost of the resource was. That was the intent of the price.
Has the commission, in fact, ever entered an order that the Hawthorne facility is in service?
The commission, no.
I think that's all I have, Your Honor.
Thank you. Is there any redirect?
Just briefly, Judge. Let's go to a question from Chair Hahn. Do you recall that you were asked a question and you indicated that the process that we're using in this case was contemplated in the 2018 tariff? Do you recall that?
I do.
Can you elaborate upon that process as you understood it?
Yes. Again, the idea and somewhat aligned with staff questions was the plan was to put forth an estimate in 2018 about what the parameters of the program would be. Then to go forth, find subscribers who would want to join the program so that we could achieve a 90% subscription and start the build of an actual resource. Once that final resource was built, we would have the costs and information available needed to finalize the pricing, and then that would be updated in this tariff, with the intent that that pricing would be fixed for that resource for the solar block charge component of the rate.
And the current rate is 8.8 cents per kilowatt hour, correct?
Correct.
And the final cost you're talking about is what?
The 9.1 that we've been talking about.
And that would be included in a filed tariff, is that right?
Correct. That would be reflected in the solar subscription rider, and that price would not change.
So consumers know what the filed price is if the commission approves that.
Correct. The only variable component in the Hawthorne pricing is the service and access component, which is a small piece that's added to the solar block cost, which would be fixed for that resource.
Does that in any way exceed any cap that's in the current tariff?
It does not.
Is there a cap in the tariff?
Yeah, well, at least going back to the 2018 original commitment, no, it's still below that number. And that estimate number is not in the, or that not to exceed number is not present, but we are true to its original intent in the 2018 version.
Is there any promise in the current tariff that says it'll never, ever increase at any point?
The solar subscription charge?
Yes.
No.
explain, if you would, how, I think the chair asked you about how it would work in a rate case. How would it work if the commission adopts our current proposal?
As far as the pricing,
Yes.
if the, within a rate case,
Well, I was thinking, no,
or absent the rate case.
our proposal, the company's proposal.
Right. With our proposal, this would just, it would be executed now, and we would carry that pricing forward for subscription under the tariff. If required to wait for a rate case, it would delay that timing, and there would be a need to coordinate between cases that may or may not be open at the time.
Would the company contemplate the possibility of adding solar facilities in the future and under this SSP program?
Surely, yeah, that's our hope, and it's our expectation that customers are continuing to want access to renewable energy, and then we need to find a way to provide that. And the language that the committee or the company has offered thus far, or in our testimony, will give us that flexibility to meet that need, even if the cost of the resources in the future are not cheaper than the Hawthorne resource today.
Well, let's assume that they're not cheaper. How would it work under the company's proposal?
Right. Under the company's proposal, if the price were higher than the Hawthorne resource, we would set that second tranche separate from Hawthorne with its own distinct pricing. And future participants would be able to judge participation based on those numbers, and the Hawthorne participants and that initial tranche would be completely unaffected by that expansion.
So their price wouldn't change.
Correct.
But on the other hand, if the price dropped under the company's proposal, how would it work?
Under our proposal, at that point, we would bring the resources together and levelize those costs, sharing that benefit, much like we originally intended in 2018. So all participants would benefit from the reduction of cost.
Under the company's proposal, at any time, would there not be an approved tariff that customers would look at?
Correct. No, there would always be the tariff pricing to lay out either the combined cost or the individual tranches would always be on the tariff.
I believe you were asked a question a few moments ago about the in-service date of Hawthorne. Was Hawthorne included in rate base before the in-service date of May 2023?
No, it was not.
Would facilities like Hawthorne be included in rate base in a rate case?
Correct, they would.
So would you expect that maybe in the future it might actually be in rate base,
Yes,
but not now?
not now, correct.
Council or staff ask you about this RPKA. For the record, would you explain what that is?
Yes, that's one of the company's residential rate alternatives, the residential peak adjustment rate.
And that is that the rate that currently is under the SSP?
Correct. That is being driven by the billing provisions of the SSP. That's the only rate that can be executed under the tariffed terms.
Do you agree with staff that the commission could decide to limit the SSP to that rate?
I do.
Why is that an option?
Right. I mean, conceptually and from the customer's perspective, I think it has value because that's the condition that all of these subscribers joined, or nearly all of the subscribers joined the program in the first place. They joined prior to the time of use rates that came into play at the end of 2022. So maintaining this will maintain a certain level of status quo for those customers where they largely are on the same condition or same style of rate. The other part of that is that it would afford the company the opportunity to avoid a number of system changes that would be required to do the more highly differentiated TOU billing. and save those potentially for when an expansion happens, and all of those things can be timed out and executed more methodically.
So you could do that pricing change the next time there is an additional solar facility coming in? Is that
Correct.
what you're saying?
Correct. All of those could be packaged and handled, and then at that point, new subscribers would be presented with consistent options. And the decision to limit to peak adjustment would keep those original Hawthorne participants in their status.
What billing changes would need to be made if the commission decides to expand the SSP to include the higher differential TOU rates?
Right. What we would have to do is configure the billing system to be able to apply the solar subscription resource output in the same manner that the billing or the billing determinants of the rates are set up. So for example, in our 2-period or 3-period time of use rates, we have different time periods, peak, off-peak, super off-peak. We would have to subdivide the resource production into those same categories so that we can net them properly. That would have to be built into the billing system.
And what kind of time frame would you have to have in order to do that?
Right. Under our current status, where everything is in the timing of this case, we've indicated the company proposals can be achieved by December.
And if it was expanded, to use the staff's proposal, I think they have the 2-step method, what kind of time frame would that be?
Right. We're anticipating that that will carry us into the subsequent May in order to do that because of the additional complexity of the steps.
When staff council asked you about the cost of the solar facility in 2018 tariff, do you recall that?
Yes?
Did the company mislead customers in order to get them to sign up for this program?
No, I mean, I don't believe it in any way. There's a certain order of things that presented a challenge, certainly, having to provide estimates and many of those things to inform customers, but in no way were we attempting to set up pricing that would be like a bait and switch kind of situation or to take advantage of customers. The entire intent of the process that was laid out was to achieve the final price of the resource and reflect it in the pricing on the tariff.
And that's what we're doing in this case.
Correct.
Now, can customers leave the SSP program?
Yes, there is a requirement that they would stay in the program for 1 year, but after that, they're free to leave.
Do you know, have customers left the program?
I don't know for certain.
My last question is, could you correct a statement from council about the life of that facility, expected life?
Right. The expected life that we have is 25 years for that resource.
Okay. Judge,
No objection.
Thank you. That's all I have.
All right. I think the questioning may have raised some other questions from the bench. So, Chair Hahn?
She's right, it did.
That's fine.
Mr. Lutz, part of the issues wrapped up in this case is, should other rate options be available to SSP customers? Can you describe the attributes of the 750 customers that subscribe to the SSP program? Like, what types of customers are they?
By far, they're residential. That's our highest percentage. I myself am a subscriber, for example. Other aspects you're interested in?
Education level, other
I'm not certain I have access to any demographic data. I would say it would be a cross-section, would be my guess.
I'm curious, my suspicion is that the people that the types of customers that subscribe to SSP are also similar to the types of customers that are highly interested in high peak differential TOU rates.
Possibly. Again, I'm going to rely on maybe my own situation, which maybe or may not be the best. But for me, the decision was driven by the fact that I own an older home in an old neighborhood that probably doesn't have a lot of future value. So I'm not interested in putting solar panels on my roof. And so this was an alternative for me to get into a renewable program without having to do anything on my premise. So to say that it automatically is linked to TOU, I don't know if I could say that for certain. I know I'm on the peak adjustment rate, and a number of my local neighbors are in that same category, just simply because of our home situations don't lend itself to the TOU periods very well. But no, I'm not aware of any evidence that there's an alignment between TOU interest and solar subscription participation.
Okay.
Maybe if I may, I would say we've not seen folks unsubscribe or express complaint about that availability. So I'm not aware of it.
Okay, thank you. On one of the issues raised in Mr. Graham's opening statements was on the customer FAQs for the
Yes.
solar subscription program. And it said the cost wouldn't increase if there were, I'm paraphrasing, lower solar generating units in the future. But in a way, and the first part of what I understood of that statement, or the answer to that FAQ, was no, your rates aren't going to increase. Do you interpret that the same way, or do we have that exact FAQ language?
I do not have the FAQ language in front of me. I think it was offered as an exhibit, maybe in this proceeding was the first time that I saw that language.
Okay. So you were not aware prior to this proceeding of that FAQ?
Only the reference in Mr. Cunningham testimony. I think it was in his direct or rebuttal. He mentioned a customer complaint. That was the first that I had heard of the complaint.
Okay. Okay. Another part of this case has to do with expanding the SSP program to non-residential customers.
Yes.
Potentially commercial customers that are interested in, their renewable portfolios.
Yes.
Can you speak to, your company's interactions with those non-residential users and their desire to participate in these programs?
Right. What we're seeing, and it probably first took root with our largest customers, but as you common, it starts to filter down into the smaller categories as well. But companies are becoming very aware of those renewable needs, and like there's the ES&G initiatives within like investing communities and those kind of things. But all of those have driven our non-residential customers to seek alternatives, and this solar subscription program, it provides that opportunity. Now, the problem that we have is that when we designed the program, it had a number of constraints on it to get it stood up. But now that we have the program in place, we have some processes, we have the wait list, for example, we believe that there's now an opportunity to take the training wheels off a little bit and allow us to make the system or the program a little bit more flexible so that we can address those needs. The needs vary. Some customers just want to be able to participate in green energy programs. Other customers need renewable energy certificates potentially, so that they can achieve some kind of authorization or affirmation of their renewable participation. So it tends to vary, but definitely the solar subscription is one that's brought to the table frequently as an option.
Okay. I'm not sure I'm remembering exactly accurately, but one of the concerns I thought staff had with expanding the program is then the unavailability of the program to the residential customers.
Right.
Can you speak to that?
Sure. I think what the concern was is that some large non-residential customer will come to the table and consume the entire resource that's being added. What I would offer and what we believe is the fail-safe or protection for that is the wait list that we currently have. any person can join the wait list at any time, and those customers are served in that order. So even if a large non-residential customer would come to the table, they would be added to the wait list just like everyone else. And so when we added the resource, whatever that size might be, we would serve all of those customers in that order. So residential, non-residential would get served in that order. So there's not a risk of that non-residential customer coming in and claiming the entire resource like we had with the introductory resource. With that first one, it really felt like there could be a risk where maybe the residential customers didn't act quickly, and, you know, a large customer comes in and says, I'll take the whole thing. We wanted to protect from that, and it worked, and we achieved a high residential enrollment. But now the wait list is there, and that's the way we would ensure that no matter when the residential customer expressed their interest, they would be served in the order where they joined the wait list.
Okay. One other question. I think today has been a little surprising to me that the price of installing a solar facility could be more expensive in the future or than contemplated originally than previously, driven by interest costs and other things, given the amount of federal incentives to do just this. So I'm not sure I'm understanding how. I might need a more concrete example of costs to help, you know, wrap my mind around how it's more expensive. I get labor costs are more expensive and materials are more expensive, but it seems like the federal incentives to do just this are intended to offset that plus more. So can you speak to that?
Right, and the other aspect I would say is that there's a certain demand out there that's growing as well. So the available solar resources that are available are being consumed more quickly. So, you know, all of those things are working in conjunction. I would also offer that the Hawthorne resource was started prior to many of those externals factors coming to the table. So it benefited from timing, and the price is maybe a little bit lower than what you would normally expect, I think, is part of the answer. It's a relative issue in some respects. The future resources relative to Hawthorne. Mm-hmm. It's maybe they're still cheaper than they were at some other period of time, but with respect to the solar subscription program and its current tariff language, we're constrained by Hawthorne now and can only expand if we can find programs that are cheaper than Hawthorne. And so that just limits our ability to address those customer needs. Under our proposed language, it at least gives us an option to stand up an alternative, even if it's more expensive. Hopefully, to your point, it does come down or become cheaper, because that's where we prefer it to be, and would certainly share all of those savings with customers if those future resources were added more cheaply.
Yeah, I understand, you know, I can see where more resources need added to serve more customers who are interested in this, and certainly wouldn't want to constrain their ability to participate in a program just because of a prior, but I'm just trying to.
Right, and unfortunately, Kevin Brandon might be a little bit more familiar with some of those cost aspects. That was an area of his testimony, talking about the cost of the resource and some of the work that we went through there. Mm-hmm. So admittedly, I'm not fully versed on all of those dynamics around the pricing, but anecdotally, those would be the thoughts that I would offer.
Okay, thank you, Mr. Lutz.
You're welcome.
Are there any additional commissioner questions? All right, I will give the parties a chance then to do further cross-examination based on the chair's questions. Mr. Graham, anything?
Yes, thank you. I'll do the best I can with formulating these questions. First of all, let's see if we can be clear here. The company does leave open the possibility of raising the block rate for customers who have already subscribed to the program. Is that correct?
The solar block charge once revised to reflect the pricing we've suggested here, will not change.
I'm going to ask it again. Thank you for that clarification. Would you agree then that for those customers who have subscribed to the solar program, they can anticipate that their solar block charge might increase? Yes or no?
I would say no.
So
If I'm limited to yes or no, I have to say no.
by the orders that will be entered by the commission, that increase will be foreclosed, not as a practical matter, but as a legal matter.
I don't know if I can answer the legal matter
Okay.
element.
Now, I took it from some questions and answers that I've heard here before that perhaps you may or may not be aware of some things that are out there. May I approach the witness?
Yes.
I'll try not to talk while I'm doing it since we're on mics.
Please.
Thank you.
Thank you, sir.
Do you have an extra one of those, Mr. Graham? Thank you.
Let me say for the benefit of the court reporter that I have handed, correct me if I'm wrong, sir, the witness exhibit number 107. Is that correct? You see that up in the
I
right-hand
have
corner?
that, yes.
And would you agree that this exhibit, for the benefit of the court reporter who's not here, is entitled Solar Subscription? And then under that title appear the words Mo Metro and Mo West frequently asked questions.
I see that.
Did I read all that correctly?
You did.
Have you by any chance seen this document before?
As in this form or at all?
In this form, let's just take it in baby steps.
No, this exhibit was offered maybe a day or two ago for this case. So I saw it in the exhibit form,
That went through your counsel?
yes.
Okay. Did you have a chance to look at it?
Yes,
Okay. I would direct you then to page 2 of the document, into the words, or the question, will my solar subscription charge be subjected to additional increases in the future? Did I read that correctly?
yes.
And did you see that as you examined this document before you came here today?
Yes, I would agree with that.
As a general foundational question, do you quarrel with or do you have any dispute with the proposition that the company at some point in time published this document out on the internet for people to read and see?
Yes, I would support that.
You agree that that did happen?
I would support that we offered an FAQ, yes.
Do you dispute that this particular frequently asked question and answer was in a document or in a posting on the internet?
No, I would not contest that.
The company will agree to that proposition.
Yes,
Okay, I'm going to read this off and see if I've got it right. Will my solar subscription charge be subjected to additional increases in the future? Did I read the question right?
you did.
The solar block, here's the answer. The solar block subscription charge for the cost of the resource will not increase and may go down if we install additional cheaper assets. Did I read that correctly?
You did.
And do you, on behalf of the company, admit that that question and answer was published on the internet, at least as of May 2023?
I would accept that.
And the company admits that?
Yes,
Okay. Now, would you agree that that was intended by the company? Let me ask my questions, okay? Would you agree that that question and answer was actually pre-prepared by the company for publication on the internet? You didn't actually receive a question on the internet somewhere or through an email or something.
Correct. This is our attempt to anticipate questions and provide responses to those. Yeah, that's a typical format for these
Right, so
FAQs, yes.
So the company anticipated being asked this question.
Yes,
The company anticipated being asked whether the solar block charge would increase. Correct?
the subscription charge. I need to be careful because there are components of the charge. So I want to be careful because where this is leading is to the delineation of the charges that make up the solar subscription charge.
Being put on the internet meant that it was leading to the reasonable understanding of a person reading the information on the internet. Wouldn't that be a fair statement?
Objection, Your Honor. I think that's calling for speculation and is argumentative here.
I'll lay a foundation.
Go ahead
For
and lay
your
your
rule.
foundation.
When you put this question together, and by you I meant Evergy, you were speculating, conjecturing, and wondering what a prospective customer would think. That was actually what you were trying to do, is what counsel objected to. You were trying to figure out what a customer would be thinking when you asked and answered this question for yourself on the internet. Am I right?
Objection, Your Honor. I lack a foundation. This witness had anything to do with the preparation of that website answer.
That's a fair point.
I'll sustain the objection.
Thank you. Okay, so I'm trying to figure out now which, as we go forward here and we change the solar block rate, will that, I'm not clear on this, will that change apply to persons who have subscribed in this program already, all the way back to the beginning? Can they anticipate that the solar block charge will increase?
Once the solar block component of the subscription charge is changed as proposed by the company in this case, it will no longer change. The solar block cost will become fixed going forward.
Well, sir, this document speaks for itself, and it does not say that, does it?
Well, there was a revision to this FAQ after this point was raised. I'm not sure when the timing was. This was a topic addressed by Mr. Brannon in his testimony.
So this was wrong.
Yes.
What we've read here out of Exhibit 107, and at this time, lest I forget, I'm going to offer Exhibit 107.
Would there be any objection to exhibit number 107?
Judge, we won't object as long as we can put in the revision that was made to this.
I guess I'm asking if you have an objection to this exhibit.
I have an objection if we are not allowed to put in the revision to this tariff or to this website. But I would offer to do that, and with that, I would say we would not object.
And would staff have an objection to what would be marked as Exhibit 6?
What is Exhibit 6? I'm sorry, I've got a number of things being said to me by various folks at this time.
The company is offered as Exhibit 6 to put in the revised version of the FAQs.
No, I don't have any objection to that.
Okay, I will ask Mr. Fisher if you would, on our next break or whatever, unless you already have copies of that.
Yes, I think staff actually marked it as Exhibit 108.
Okay. Then I don't need to mark it as Exhibit 6, do I? Didn't realize that was the same, talking about the same thing. So, I guess we've then had Exhibit 107 and Exhibit 108 offered. And
And where are we on the 107?
I was getting ready
I'm
to
sorry.
go ahead and just rule on both of those. Those are both admitted, given that in tandem there is no objection.
Okay. Now, just a couple more. The tariff language that has been proposed that's before the commission now for either approval or disapproval, would it be a fair statement that it removes I'm going to just rough and ready at a 13 cents cap on the increases on solar block pricing?
Yes, because the purpose of the 13 was just to establish a ceiling for customers, prospective subscribers to consider.
To rely upon.
We now have the actual pricing for the resource available to us, so the estimate is no longer informative.
I'm asking partway through your answer, and I apologize for stepping on you and interrupting you, but sometimes I have to grab my idea before it passes, even though it's a terribly important idea. But that was a 13 cents cap that the customers were intended to, the company intended the customers to rely upon that, didn't they?
For the solar block charge component.
Exactly. So customers aware of that tariff at that time when they were signing up were given one number. I think it was what, 11 cents or something, but I'm not sure about that, but they were reassured that going forward, and it would have to be forward because it would not be the rate that was being estimated for that time. They were being told that they could rely upon a cap of 13 cents that would not be triggered until sometime in the future when the number looked like it should be 14, and you were saying, don't worry, not to worry, it'll be 13. Am I saying it right?
Not entirely. I must delineate that the cost that is being subject to the not to exceed amount is the solar block cost, which is a component of the overall charge. There's a service and access charge that's added to that to get to the subscription charge.
Okay, but you're taking that component out of this current tariff that's now before the...
No, the components are still there.
No, that 13 cents is gone. Look at your own tariff that's before the commission today.
Agreed. However, the applicability to the solar block cost is maintained. Our solar block cost of 9.1 is below the 13.8 of the ceiling that was offered in the original tariff.
I think we understand each other. What you're saying is you're withdrawing the promise for the future.
No.
The 13 cents is gone.
It is, because the 9 is now present and is the fixed cost going forward.
I'm sorry, I misunderstood the tariff that's before the commission. I thought that was an estimate.
Counsel is testifying now, Judge.
Well,
Mr. Graham, if you stick to questions.
I'll stick to that. Yes, I understand that objection to the form of the question. The tariff that's before the commission that's disputed today has removed a 13 cents cap for the future, right?
With respect to the solar block cost, that is true, because the 9.1 is reflective of the true cost.
But is the solar block cost that is now in the tariff still qualified, look at your tariff, with the word estimate?
Under the currently effective tariff or the
Sir,
proposed
the one
tariff?
that's proposed.
I'm not sure I don't think I have my specimen from my rebuttal. Is that suitable?
Well, I'm not sure because if we can just pause a minute, Your Honor. minute recess so I don't have you just sitting up there. I need to look at some documents here.
Okay, we can go off the record while the council confers. The record. We took just a little pause there for council to get his questions figured out. And in the interim, Mr. Fisher passed out copies of his opening statement documents that I labeled as Exhibit 5. So, go ahead, Mr. Graham.
Thank you for your patience. After going through all these documents, I can see through all of the iterations that this has gone through, that this word estimate has finally been removed with respect to this solar block charge from the tariff that is now before the commission for approval. Are we in agreement on that?
Yes.
So, so at this point, the language of the Q&A that I was looking at, the company is not withdrawing that language or that commitment to prior subscribers, persons who have subscribed to the program, that the solar block charge will not increase in the future.
The solar block cost component, yes, I agree.
Okay. What is it you want me to ask? Because of the line of questioning here that's gone this way and that way in the last few minutes, I must ask, I'm looking at your red line tariff here. Has that one been filed?
Just as a exhibit, a specimen tariff here for commission consideration?
Okay. So it's not a live tariff?
No.
Okay. The one that we have been dealing with was suspended, but it had the word estimate in it.
It's possible.
All right.
That's the one I don't have. What has progressed is with staff offering a specimen in rebuttal, I think it was, and ours in sur rebuttal, we're kind of developing alternative languages on the fly, it looks
That's
like.
why you and I have been swinging past each other.
I believe so.
All right. Thank you very much for your patience with me.
No problem.
Is there a redirect?
Yeah, just briefly, Judge. I don't know, do you even have a copy of 108 in front of you?
I don't at the time.
Okay, well, just to make it easy, let me read what it says, and I'm going to ask you, is this corrected version correct, okay?
Okay.
Okay, the exhibit says, will my solar subscription charge be subjected to additional increases in the future, question mark. And the answer in the corrected version is, while the solar block energy charge for the cost of the Hawthorne solar resource will not increase once the updated charge is approved by the Mo PSC to reflect final costs of the completed resource, the services and access charge may change during future Missouri rate cases. Would that be true?
Right, and I would further add that that aligns with the expectation of the commission-approved tariff.
And is it your understanding a approved tariff would supersede whatever might be stated on the website too?
Right, right, and the FAQs are intended to try to get ahead of questions and in their entirety, hopefully can help inform customers. I noted that on one of the earlier questions, there's an exploration of the components of the charge, and it did delineate that the service and access charge was subject to change, for example. So if a customer did read the FAQs in their entirety, I think they would have a more balanced view of the program.
For the customers that have subscribed to the current program, which includes the Hawthorne facility, do you contemplate that solar block rate would ever go up unless, or what would it ever go up?
Correct. The solar block cost will never go up after this final change, and it would only be able to go down if future resources were found to be cheaper than this cost.
Okay. There was a question from the chair about, I think, federal grants or federal subsidies, incentives related to solar. I'm not sure it's in your area, but do you know if Evergy is eligible for federal incentives?
I don't know.
Okay. And given this line of questioning, are consumers being charged more than what we suggested in the original tariff, that 13.1 cent?
Correct. Under the solar block charge that we have currently and the one proposed in this case, neither are above the 13.8 that was estimated in 2018.
And in the future, if the company wanted to build another solar facility beyond the Hawthorne one, would the company have to come in and get a certificate of convenience and necessity from this commission, and they would be looking at what the cost of that unit might be at that time?
Absolutely. And then there would be a further revision of this tariff to introduce that pricing and that resource to this tariff. So there would be multiple places where those could be examined.
And that's what's contemplated in our existing tariff proposal, correct?
Correct.
Okay. Have current solar subscriber customers complained to the company about any aspect of the program that you're aware of?
I'm not aware of any.
Thank you. That's all I have.
Thank you. Okay, Mr. Lutz, I would think that completes your testimony.
Okay. All right. Thank you.
I think then we are ready for staff's first witness.
Staff will call Tariff Lange. Okay,
Do you solemnly swear or affirm the testimony you're about to give at this hearing will be the truth?
Yes.
Thank you. You may go ahead, Mr. Graham.
Thank you, Your Honor. Can you hear me here?
Yes.
Would you state your full name, Ms. Lange?
Sarah Lynn Cleathramus Lange,
Okay. And where are you employed at this time?
staff of the Missouri Public Service Commission,
What is your position?
economist.
All right, and have you prepared and filed testimony in this proceeding?
Yes.
Have you filed direct testimony numbered Exhibit 100, rebuttal testimony numbered 101, and surrebuttal testimony numbered 102?
Yes.
Do you have any changes or corrections to make to any of those documents?
A qualified yes. My surrebuttal testimony addressed the addition Mr. Lutz had made in his rebuttal testimony to include the EV-only charging. It's my understanding that his testimony this morning, he entered a correction that removed that portion of the testimony. So my surrebuttal testimony largely addressed that issue that I believe is essentially moot from the company's perspective, but may or may not be moot from the commission's perspective.
Yes, but you don't propose to take any words out.
I don't think so.
Okay. Now, if I were to ask you the same questions that you were asked, so to speak, of yourself in that testimony that you've referred to in Exhibits 100 through 102, would your answers be substantially the same?
With that caveat regarding Mr. Lutz's substantive change, yes.
And are those same answers true and correct to the best of your knowledge and belief?
Yes.
I'd offer Exhibits 100, 101, 102 into evidence.
Would there be any objection to Exhibits 100, 101, and 102? And I might add 100, both 100 and 101 have confidential and public versions.
No objection, Judge.
And I would tender the witness for cross-examination.
Okay, I will admit those
Oh,
documents.
thank you.
All right, then, is there any cross-examination by Evergy?
No, thank you, Judge.
Are there questions for Ms. Lange from the commissioners? Chair Hahn? Go ahead.
Good morning, Ms. Lange.
Good morning.
I'm going to ask you some of the same things I asked Mr. Lutz, though some of them I think have been clarified since I asked, so I'm going to ask for your perspective as well. But in Mr. Fisher's opening testimony, he stated that this tariff change was previously contemplated in a 2018 case. And Mr. Lutz testified that the parameters of the program, the subscribers, building of the resource, and then finalizing the pricing was how it was contemplated. Do you agree with Mr. Lutz's testimony, or do you have a different thought as to what was contemplated in the 2018 case when the program was designed?
If you'll give me just a moment, I'm making some notes so I don't leave out something important.
Of course.
Okay. So I can't give you a simple answer to that because there are multiple tariff changes proposed here today. As regarding the block charge itself, which I think is what Mr. Lutz was referring to in his testimony and in Mr. Fisher's opening statement, I would defer to Mr. Cunningham regarding that. With regard to the expansion to add facilities and how that tariff change has occurred, Mr. Cunningham can speak in greater detail, but I do not believe that that was contemplated. They're changing the tariff on that language. The change to give C&I customers the ability to subscribe up to 100%, that was not contemplated. The change to reduce the non-residential waiting list, that was not complicated. Mr. Cunningham may be able to speak to additional detail on those matters. The items that I address with greater particularity on billing provisions, those were not contemplated.
Okay. Also, I asked Mr. Lutz, and Judge Dippell did as well, about the Hawthorne plant being placed in service. Mr. Lutz testified that it was operational in January of 2023, though not, the engineering completion or site visit wasn't completed until the end of May 2023, but customers paid retroactively back to April 1st, I think. What's staff's interpretation of Mr. Lutz's testimony, and what is staff's opinion on the placed in service date?
So my understanding is that they were billed retroactively to January of 2023.
Okay.
I am not aware that the commission has made a finding that the Hawthorne facility is fully operational and useful for service. Details about those dates, I would defer to Mr. Cunningham, but if the commission had made that finding, I would know, and they haven't.
I also asked Mr. Lutz if there are similarities on customer types between the types of customers who are interested in solar subscription program or interested in high peak differential TOU rates. Just based on your experience, do you think that there are similarities between these customer types, or do you have any knowledge of how, one particular type of customer might also lead to have similar attributes to another type of customer?
I believe there's two sectors of customers who would overlap based on my, familiarity and experience. I haven't done, surveys, although I believe that Evergy has done cohort surveys that tend to lump these sorts of optional programs together, TOU formerly being an optional program. And that would be customers who are interested in energy arbitrage, I think would have overlap, and customers who are what you might call technologically engaged, early movers, those sorts of customers, particularly if they live in an apartment or a condo or some other environment where they would not be able to add their own solar panels to their home.
I asked Mr. Lutz about the availability of the SSP program for non-residential customers, and also, the economic development desires of certain companies for those types of things. His response was that in order to, and I summarized staff's concern being that if you open the solar subscription program to non-residential customers, they may overwhelm the ability of the residential customers to access the SSP. His response was that in order to alleviate that concern, they have a wait list. Can you speak to how staff's view of that wait list as to alleviate those concerns, or that concern?
Can I answer your question with a question, which I guess I just did? If you could defer that specific question to Mr. Cunningham, I think your question actually raises a very important point that hasn't really come out in this case thus far, just given the way it's structured, which is that in general, there's the concern about how customers within the program are treated. We want to ensure that they're treated fairly and rates are just and reasonable. But there's also the balance between the interest between participants and non-participants. And so the language about how program expansion works and ensuring that we don't, if you will, build a large facility for a customer who may or may not be there in 5 years, that goes to the concern about making sure that non-participants' interests are protected. And I haven't heard Evergy explain how that concern is assuaged, and I don't see how that concern is assuaged. The answer can't just be keep building more solar, because at some point, customers may want out. You have to be mindful of how much is too much, how much is the right amount at the right time.
That does bring up another question. I'm not sure if I should ask you now or if I should ask Mr. Cunningham, but could there potentially be different contractual terms for an SSP subscription for a non-residential user to alleviate those concerns?
Well, absolutely. I mean, the company can and does file tariffs for new programs all the time. If you'll pardon the expression, shoehorning future facilities into this program, if they want to change this program, it would just seem to me the easier thing to do is to create a new program for new facilities that would be fully evaluated in a time frame that's not as truncated as this one being truncated due to the issues with the billing provisions.
Okay. I think that's all I have.
Thank you.
Thank you.
Are there any other commissioner questions? Anything online? All right. Is there, I don't have any questions for you either, Ms. Lange. Is there any recross from Evergy based on Commissioner Hahn's question?
No, thank you, Judge.
Is there any redirect from staff?
No, Your Honor.
All right, then, Ms. Lange, I believe that concludes your testimony.
Thank you, Judge.
I think we can go ahead then with staff's next witness.
Call Mr. Cedric Cunningham, please.
Do you swear or affirm the testimony you're about to give at this hearing will be the truth?
I do.
Thank you. And go ahead, Mr. Graham.
Thank you, Your Honor. Would you please state your name for the record and spell it?
Cedric, C-E-D-R-I-C, Cunningham, C-U-N-I-G-A-N.
And by whom are you employed?
The Missouri Public Service Commission,
And what is your position with the commission?
Senior Professional Engineer.
Have you prepared and filed testimony in this proceeding?
Yes.
Have you filed testimony in the form of direct testimony, rebuttal testimony, and surrebuttal testimony?
Yes.
To your knowledge, is that testimony marked as direct testimony, which is Exhibit 103, rebuttal testimony, which is Exhibit 104, and surrebuttal testimony that is Exhibit 105?
Yes.
Do you have any changes or corrections that you wish to make or you believe is necessary to be made to these documents?
No.
If I were to ask you all the same questions that were asked of you in those documents today, would your answers be the same or substantially the same?
Yes.
And are those same answers true and correct to the best of your knowledge and belief today?
Yes.
I'd offer into evidence staff's exhibits 103, 104, 105, and tend to the witness for cross-examination.
Would there be any objection to exhibits 103, 104, and 105?
No objection.
Thank you. Is there any cross-examination from Evergy?
No, thank you.
Are there commissioner questions? Chair Hahn?
Thank you. Good morning, Mr. Cunningham. I am going to just ask some of the questions that I asked Ms. Lange of you instead. As she suggested, can you, in Mr. Fisher's opening testimony, he stated that the way the program was designed was contemplated in the 2018 case, speaking as to the parameters setting up the parameters of the program, finding subscribers for the program, then building the resource and finalizing the pricing for the solar subscription block once the resource had been finally built. Do you agree with that, or conceptualization, or do you have a differing opinion of how this was contemplated in that case?
I would disagree with that. We had the original 2018 rate case where the program was proposed, but the facility was not built yet. So if you go and look at that original tariff, it has estimated in that cost because there was no facility. And then there was supposed to be a facility chosen and a final price put into the rates, and then that would be the only price customers ever paid. What we have here is they've put an interim rate and then adjusted it just a few months after they actually started billing it higher. And I can actually point you to the rebuttal testimony of Bradley D. Lutz on page 3, where he's quoting his testimony from the 2018 0145 0146 ER 2018 0145 0146 case, where it says, can this cost change in the future? He says, yes, the company will file a revised tariff to update the solar block charge if these proposed rates do not appropriately reflect the cost of the initial system, and again, if additional solar resources are added to serve our subscribers. So those are the only two instances where it should have been updated, is when the final cost was realized, which should have been once, and then if they added additional facilities, there was the idea at that time that the cost could be decreased for current subscribers if those facilities came in at a lower cost.
Okay. The last question that I asked Ms. Lange had to do with the creating a wait list to alleviate the concern of non-residential customers being able to join the SSP. Can you speak to that?
So the wait list, the 3-month requirement was originally there to allow residential customers to get in. The 3-month requirement is not as important now as it was then, but Ms. Lange did bring up the issue of how the total program allocation, if you could say that, we don't want a program that is essentially 90% non-residential customers, but then if that program becomes unsubscribed, that falls back on all customer rate base to cover that. So there are things in the tariff. I believe you asked another question on a time limit, and the current tariff actually does have a condition in there that says, I'll pull it up real quick. Okay, so I'm looking at the Evergy Metro tariff. This is PSC mode number 7, third revised sheet number 39C. Under the subscription term, it says non-residential participants who subscribe to 25% of the available solar blocks for a given resource are required to commit to a minimum term of 5 years. So with the resource life expected to be anywhere from 25 to 30 years, given average life for solar, it has a condition in there to say that, if you are taking a large chunk of this, you're on the hook for a little longer than the average residential customer, who would typically just be the 12 months.
That brings me to another question. I think Ms. Lange said you could design another program. Is it, to alleviate other contractual concerns with making sure that the asset is fully subscribed for its useful life? Could you modify this particular program to just take that into account versus creating a new program?
I think you could do either option. At a certain point, large enough customers have the option of entering their own contracts with the utility outside of any program.
Thank you. I asked one other question of Ms. Lange. I think she also deferred me to you on it as well. To me, it seems like there could be similarities in customer types between those that are interested in the SSP and in high peak differential TOU rates. Do you have experience in that, or can you speak to that at all? If there are similarities, do you think, in customer types?
Yeah, I think that one would be a little bit out of my wheelhouse. I would say, generally, though, I would agree with her saying the first movers, people who are going to be more knowledgeable about technology, people who are limited in their ability to place solar on their own homes, those kinds of customers would be more likely to join the program.
Thank you.
Are there any other commissioner questions? Anything from online? All right. I just had one clarification, Mr. Cunningham. You cited us to tariff language in a specific page. That is the currently effective tariff?
This is the currently effective tariff for Evergy Metro with the effective date January 9th, 2023.
Okay, thank you. Is there any further cross-examination based on Commissioner and my question?
I have just a couple. Mr. Cunningham, you cited to Mr. Lutz's testimony from that 2018 case in answer to Chair Hahn's question. Do you recall that?
Yes.
What, from your perspective, is the final cost of Hawthorne? Is it the 8.3 cents or the 9.1 cents?
I think that final cost is what we initially thought was the 8, that what was approved in the 2022-0130 and 129 case. We thought that was the cost that would.
Was it your understanding that was an estimate based upon the Greenwood solar facility?
The way the company did their pricing for the program at the time, it was all based off of estimates for production of energy. It's based on a levelized cost of energy model. So it's always going to be an estimate based off of that model.
They had a Greenwood solar facility at that time, right?
Correct.
And that was the estimate that was used for the 8.3, but the 9.1, isn't that your understanding that that's the final cost?
That is my understanding of the cost that they are saying for Hawthorne now. It was never the intention to charge an estimated cost, though, based off of Greenwood.
The tariff would speak to that, correct?
That goes back through several cases worth of stipulations, and it's a little convoluted now with how many different tariffs we've had. The original intent was to have a price to charge customers or to get subscribers, and then a final price that would actually be charged.
Staff has not, I guess, asserted that the company has not charged a tariff price, right? I mean, we've charged the tariff price, correct?
You charged the price that was in the tariff.
And that was approved by the commission.
That tariff was approved. It was not intended that The price would increase, though, from the original stipulation and agreements. It was intended to have a price that you got subscribers with, that you could advertise with, and then a final price once the facility costs were known.
Well, Mr. Lutz's testimony that you referred to said the company will file a revised tariff to update the solar block charge if these proposed rates do not appropriately reflect the costs of the initial system, correct?
That is correct, and that's from the 2018 case, which is referring to a different price that wasn't actually charged.
Okay. And then you were asked a question from the chair about similarities between customers, TOU customers and SSP customers.
Yes.
The commission staff's position statement, I think, agrees with the company's perspective that the commission may properly determine that it is appropriate that customers not be able to participate in the SPP while taking service on more differentiated TOU rate schedules. Is that right?
Say that again.
Maybe I can just show it to you, but the staff position statement says the commission may properly determine that it's appropriate that customers not be able to participate in the SPP while taking service on more differentiated TOU rate schedules.
I believe that was an issue Ms. Lange spoke to.
Okay, so you're not the appropriate witness. I was going to ask you to give a perspective on why staff's position is that.
Yeah, that would be a Ms. Lange question.
Okay, thank you. That's all I have.
Sorry, is there redirect from staff?
Okay, the chair asked you, Mr. Cunningham, about.
Can you pull the microphone over a little? Thank you. Go
Chair
ahead.
asked you about a joint residential, non-residential program that would be more complicated, correct? You recall that line of questioning?
She asked about modifying the current program.
Would you agree that a combination of residential and non-residential subscribers would be more complicated?
I think that does add complexity to the program.
All right. Just to make sure I've done my housekeeping here, if you can help me on this. There was a whole line of questioning that you listened to between me and Mr. Lutz on which tariff we were talking about. The document that removes the word estimate from the description of a price related to the solar block program appears in a red-lined exhibit to testimony, correct?
Judge, I'm going to object to that. That's beyond the scope of any cross or any questions from the bench.
My only response is and counsel is absolutely correct, but it's a matter of clarifying where we are clerically in terms of our documents. Which tariff has been filed and which tariff has not been filed? Which tariff is before the commission for decision? Which tariff is not?
It's still improper redirect, Your Honor.
I'll make the point in the brief then, if counsel doesn't want it made on the record, which is kind of an interesting position.
I will sustain the objection. However, just so that the record is clear, I will allow you, Mr. Graham, to ask the question, and I will allow further cross-examination if that is necessary.
So this is sort of in the nature of an offer of proof.
This is in the nature of making sure that we're clear about the tariffs.
Okay. And Mr. Cunningham, if you don't know, that's fine on this if you're not quite up to speed, so to speak, on this, but during the examination of Mr. Lutz, we were going back and forth, you recall, about whether the language that is before the commission today for approval or non-approval includes the expression estimate with respect to the solar block charge. You were here for that examination, weren't you?
Yes.
And it's your understanding that the company is not now advancing or advocating for a tariff that refers to that expense as estimated. Do you understand that? Is that what you heard here?
Yes.
Just to be clear, though, to your knowledge, there is no tariff that's actually on file in EFIS that withdraws that word estimate with respect to the solar block charge. This is a matter of housekeeping. Have I said it right?
So the tariff that is on file, I don't have in front of me, but I don't believe so. The tariff that Mr. Lutz was referring to was attached to his surrebuttal, and like he said, there have been specimen tariffs that have gone back and forth between staff and the company, but none of them has actually been filed. I forget if it's a JE or whatever the...
Doesn't have a tracking number.
Yes, it doesn't have a tracking number.
It's not before the commission for decision.
Yes.
That's all the questions that I have.
Now, Mr. Fisher, if you would like any further cross-examination based on that.
I don't think we need that, thank you.
Okay. All right, I think I'm more clear with regard to what the tariffs are and the back and forth with the different tariff language. So is there, I believe then that is all for Mr. Cunningham, and he is our last witness, but I do, before he steps down, I wanted to clarify, staff had on its exhibit list, Exhibit 106, which was a consumer comment. Is that anywhere in the record?
It's not in any testimony, and I didn't tender it.
I reference it in my testimony, but it was not attached to that testimony.
Okay. I just wanted to make sure.
I don't.
And is the currently effective tariff attached to anyone's testimony?
I don't believe so, Judge.
Would there be any objection to the commission taking administrative notice?
None from
of
the company.
Currently effective tariff?
No, in fact, I was actually about to make a motion to that effect.
Okay,
No
I'm going to
objection
go
from
ahead
staff.
and give that an exhibit number, just so that it's clear in the record. So that would be Exhibit 109. I'm just going to put it under staff's. And I'm going to ask staff if they would be kind enough to pull a copy of that and get me a copy of that. If you could send that to exhibits@psc.mo.gov. And Mr. Cunningham, I believe that concludes your testimony, and you can step down.
Thank you.
So with that, we've heard all of the evidence. I did want to also clarify, Mr. Fisher, if you could send that corrected copy of your opening statement as it was presented, if you could also email that to exhibits@psc.mo.gov, then we'll have in the record the exact thing that was shown on the board.
Oh, okay, so I should make a correction. My copy was not the corrected version. I'll send you the corrected version.
Yes.
Yeah, okay, gotcha.
Send that to the exhibits email
Right, okay.
address.
One more time, that address?
It's exhibits@psc.mo.gov. And if you would just copy counsel on that. when
Sure,
send
thank
that.
you.
And Mr. Graham as well, when staff submits the tariff. Okay, with that, I believe all of the exhibits have been admitted that were offered. We have a hearing date. I had asked for somewhat expedited transcripts for this because we were operating under a expedited procedural schedule. So I've asked the court reporter to get those transcripts to the commission no later than April 9th. And I will get them in EFIS as quickly as after I receive them as I can. We had a briefing, we had done one round of briefs, so briefs are due on April 19th. Is council still, is that still the schedule council is intending? I'm not seeing any.
We'll always take more time, Your Honor, but we can live with that.
Given the nature of this case, staff doesn't want any more time than has been ordered.
Okay,
We want this moved along.
we'll keep it at April 19th then.
That was not my personal opinion.
All right. Is there anything else before we go off the record?
Thank the commission for your attendance today.
Thank you, Mr. Fisher.
Thank you for your patience today.
Thank you, Mr. Graham. We can go ahead then and go off the record.